Good day, ladies and gentlemen. Joy Stephen from the Paulin's Studios, and here is another case law for the Student Herald, Canada versus Alsha'bi. Case laws are not meant for people interested to apply for permanent residence to Canada, but may be used by those who feel the system may not be fair or to gain an understanding of the recourse available in Canada for a negative decision. This case law is comparable to the previous one except that it has got additional content. Content for this video is sourced from information distributed by Thomson Reuters. Judgment for this case is attached in my blog, reportersreport.com, as a PDF document. This is an immigration case law and includes topics like refugee status, requirements. Refugee claimants were mother and two children who were stateless Palestinians. Refugee claimants and father had apparently lived in Syria before moving to United Arab Emirates, UAE, as temporary residents since 2001. Refugee claimants allegedly fear being forced to return to Syria even though father was able to maintain his employment. Refugee claimants possess Syrian travel document when they came to Canada in 2014. Refugee claimants unsuccessfully applied for refugee status. Refugee claimants successfully appealed to IRB, Immigration and Refugee Board's RAD, Refugee Appeals Division. RAD accepted new evidence from January 2015 showing UAE Ministry of Interior had cancelled refugee claimants' residence permits. RAD concluded refugee claimants would be at risk of being removed to Syria if they returned to UAE. Minister of Citizenship and Immigration brought application for judicial review. Application was dismissed. Minister failed to establish reviewable error. RAD had not erred in accepting evidence confirming cancellation of refugee claimants' UAE residence permit. The scope of RAD's appellate powers was still uncertain. RAD had not exceeded its powers. RAD had made decision based on existing record and new evidence as it was permitted to do. Even if cancellation of residence permits was refugee claimants' own doing as a result of staying out of UAE for more than 6 months, their resident status was not comparable to rights of UAE nationals. Refugee claimants lacked state protection in UAE and were always at risk of being returned to Syria arbitrarily. Further, there was nothing in S96B of Immigration and Refugee Protection Act of Canada to suggest that reason why stateless claimant lost right to return to country of former habitual residence was relevant. Moreover, reading in element of fault could have far-reaching effects. If Parliament intended S96B of Act to include element of fault, Parliament would have explicitly addressed this. Interesting case, Canada versus Alsha'bi, dated December 14th, 2015 from the Federal Court. Thank you.